Hi, everyone. We are now moving on to the next chapter. We're going to still talk about defenses, but we're going to move on to the excuse defenses. Last week, we talked about the justification defenses. This week, we're going to move on and talk about the excuse defenses. So I'm going to share my PowerPoint and we can work through the PowerPoint. Okay. So we're still talking about defenses to criminal liability. Remember, we said that we have defenses and then some of them are justification, some of them are excuses. So we're talking about the defenses to criminal liability and the excuse defenses. So just as a quick review, remember the 5 things that you need for criminal liability. We already covered conduct. And then we have without justification, without excuse. So we're done with these 2. And now the last thing we have to talk about is without excuse, okay? So that's where we're finished up with talking about criminal liability. Okay, so we said, remember, criminal defenses fall in justification, excuse. So we are now moving on to excuse defenses. And remember, excuse defenses are when you say, I did it, you actually admit that you did it, but you say you're not legally responsible. There's some valid legal excuse that you can use to escape criminal liability. So when you talk about excuse defenses, there's one group of excuse defenses that are called lack of capacity defenses. So these defenses are saying that you cannot be criminally liable. There's no legal responsibility because you lack the capacity to form mens rea. Okay, so that's why they're classified as lack of capacity. Remember all the elements in our wheel of criminal liability. If you're missing one of those elements, you have no criminal liability. So lack of capacity is when you're missing mens rea. You cannot form mens rea, so you cannot be responsible. Okay, now the first one is that we're going to talk about is insanity. So we're going to probably just cover insanity in this PowerPoint, and then in the next one, we'll finish up with the other excuse defenses and then finish with just defenses in general. So we want to focus on insanity for this PowerPoint. So I just have this little test your knowledge thing about insanity, what you think. So for each of the following, decide true or false. Okay, so the insanity defense is overused, true or false. The insanity defense is limited to murder, meaning you can only raise insanity defense for murder, true or false. There is no risk to the defendant to plead insanity, true or false. Not guilty by reason of insanity acquittees are quickly released from custody. So if you're found not guilty by reason of insanity, you get to just go home, true or false. Not guilty by reason of insanity acquittees spend less time in custody than defendants convicted of the same offense. So if they find you not guilty by reason of insanity, you won't spend as much time in jail as if you were convicted. True or false? Criminal defendants who plead insanity are usually faking. True or false? And criminal defense attorneys employ the insanity defense solely to beat the rap. True or false? So the first one is false. The number of people who use insanity defense is really exaggerated. It's a very small number. It's less than 1% of all cases, and only 26% of that 1% are actually successful. So out of all the criminal cases of defenses that people raise, they really only raise insanity in less than 1% of all cases, and only 26% of those are actually successful. And of that 26%, 80% are successful because the defendant and the prosecutor agree that the person's insane prior to the trial occurring. So it shows you that it's not used very often. And when it is used, it's really not very successful. And that's why it's not used very often. Number 2, false. Only about 1/3 of all successful insanity pleas are for murder. So they do use them for lots of different crimes. It doesn't have to be just for murder. 3, false. People who plead insanity and then are found guilty serve significantly longer sentences. So what happens is if you're found insane, you go to a mental hospital and you stay there until the judge determines that you are sane enough to be released. It's up to the discretion of the doctor. So you could be there a very, very long time, even longer than what a traditional sentence would be, because you're not going to be released until the judge determines that you're sane. Number 4, false. Out of the people that were studied over an 18-year period, only 15% were ultimately released with all restraints. 35 remained institutional custody, and 46 had partial court restraint. So you don't really get out right away. You usually have a lot of oversight and a lot of control over these cases, even when they're found insane, or when they determine they're sane, there's still a lot of control over them, even when they're released. 5 was also false, not guilty of reason of insanity, spend double the amount of time. So it usually takes over double the time before the doctor actually determines that you're well enough to be released without some oversight. And then 6, false. They studied a whole bunch of cases, 118 cases, to see if people were faking. And out of those 118 cases, 115 were diagnosable schizophrenia, which you can't really fake. And so they were able to diagnose them. And of the 3 remaining, they were inconclusive. So it wasn't that they were, it's just they couldn't conclusively diagnose schizophrenia. So as you can see, the most of the cases, people are severely, severely mentally ill before they can raise it as a defense. And then the last one, false. Most people use the plea to get immediate medical care. So a lot of times the prosecutor will even agree that the person needs severe mental illness treatment. And a lot of times the jury is going to be really biased about them. So it's not beneficial to the defense to raise insanity, because most juries don't buy it. So a lot of times it's the prosecutor and the defense agreeing that the person really needs medical care and treatment. So that's just to get you thinking about the different ideas of insanity. I found this and I thought it was kind of funny. You could see the reasons for admission into a mental health facility from 1864 to 1889. So if you read through the list, it's kind of funny. Snuff eating for 2 years, grief, gunshot wound, hard study, fell from horse in war, business nerves, bloody flux, novel reading. So it's just kind of funny. And you can read why some people were declared insane in the past. How do we determine it today? We use 4 different tests. And then we have what's called temporary insanity, which we'll talk about. So you need to understand each test and how each test is used. So we're going to work through each one step by step. So if you think of them kind of on a continuum, the hardest test to satisfy is going to be Mcnaughton. The easiest is going to be Durham Rule. So Durham Rule, irresistible impulse, substantial capacity, and the Mcnaughton is going to be the order of how easy or hard they are to prove. So we're going to start with Mcnaughton. Mcnaughton is the hardest of all. In order to prove that you are insane under the Mcnaughton Rule, you have to pass two parts of the test, and you have to have both of these parts. So the first part is you have to prove that you suffer, or the defendant suffers from a mental defect. This has to be a diagnosable mental defect. So you would have to have some medical expert that's willing to testify at trial and actually diagnose them with a specific mental defect. Now, then on top of showing that you have a medical defect, you also have to show that that defect keeps the person from knowing right from wrong. So that means their brain has a mental defect that when they do something, they don't even know that what they did was wrong. They can't distinguish between right and wrong behavior. So you walk up, you kill somebody, and you don't think it's anything wrong with killing that person. That would be Mcnaughton. It's a very, very difficult test to satisfy. The Mcnaughton test is going to be used in the federal system in some different states, but the federal system uses Mcnaughton. The next one is kind of second easiest, I guess. It's called the Irresistible Impulse Test. And the irresistible impulse test still has the first requirement, mental defect. So you have to be able to show that you have a psychiatrist testify that there's a diagnosable medical defect, plus that the person was unable to resist or use self-control to stop themselves. So I always use the example of eating chocolate cake. You see this beautiful chocolate cake when you get home from school and you just want a piece. And you know you really shouldn't because it's not good for you and you're trying to lose weight or trying to be healthy. So you don't want to eat it, you don't want to eat it, but you just can't stop. You have to have that chocolate cake. That's irresistible impulse. But don't forget, you need that mental defect that causes you not to be able to control yourself. So this isn't, so Mcnaughton is the hardest. This is second from the bottom. It's much easier just to show that the person couldn't control themselves because of the mental defect. Then we have one in between the two, Mcnaughton and irresistible impulse. And this is what we call substantial capacity test. It also has two parts. Number one, mental defect, and you lack a substantial capacity to appreciate your conduct was wrong or to control your behavior. So it's kind of like a mixture of the two tests. And it's more than just can't resist. It's a substantial capacity. And it's a little less than complete lack of knowledge of right from wrong. It's substantial capacity. So it takes those two tests and kind of pulls them to the middle. This is what we use in New York. Okay, so New York kind of combines this and Mcnaughton together for their kind of test. But if you read the statute, it kind of says, when you read it, it sounds like substantial capacity. And then this is our easiest one, the Durham Rule. So remember, for all those other ones, we had two things, mental defect plus something else. For the Durham Rule, all you have to show is that the person suffered a mental defect. So no additional requirements. So that's what makes it one of the easiest tests to pass. All you need is a psychiatrist to testify that the person is suffering from a mental defect. And the only state that I know that uses this right now is New Hampshire, but it's a pretty easy insanity test. So I also had listed what was called temporary insanity. So temporary insanity is the idea that you are insane at the moment you commit the crime, but you were sane prior to it and after. So something happened that made your sanity snap for the moment the crime was committed. So you suffered, or you can pass one of those other tests, but just at the moment the crime was committed, not before or not after. That's temporary insanity. We used to use temporary insanity a lot, and then President Reagan was shot, and the person that shot him was found not guilty by reason of temporary insanity. And people were very upset about this, and they really pushed their legislatures, and it's really been like disbanded in most places. Most places don't allow you to claim a temporary insanity. You're either sane or you're insane, and you don't get this temporary status. Okay. Oh, so I wrote it. So the defendant was insane when he committed the crime, but he is now sane. Okay. Now, what do you think? If you used Mcnaughton, read each scenario and decide if the person would meet the Mcnaughton test in each of these. So read through them and then decide, do you meet both requirements for Mcnaughton? Remember, Mcnaughton is mental defect, doesn't know right from wrong. So stop the video, work on it, and then when you're ready, click back on. So the first one would depend on the evidence of the person knowing right from wrong. Okay, so you would have to have the psychiatrist talk to the person, and you would have to know, does the deluded man understand that it's wrong? Even if he has these visions, does he understand right from wrong? So even this person may not qualify. This one would not, because they would have a mental defect, but knowing right from wrong means that it's not Mcnaughton. If it was irresistible impulse, yes, but not Mcnaughton. And then the last one, mental defect. But again, can we prove that this person knew it was wrong? So you would have to have the psychiatrist ask the person and see if they actually knew it was right or wrong. Okay, so I posted this video online. I'd like you to watch it. It's this Andrea Yates case, and she killed her children. So I want you to watch it, and I want you to think about what you think about her defense. Okay, so stop the video, find the video, and then watch it and come back. Now, we have these other two concepts that go along with insanity. We have guilty but mentally ill, and we have diminished capacity. So guilty but mentally ill, this is what Andrea Yates was ultimately labeled. In her state, they used Mcnaughton. They could not prove that she didn't know right from wrong, so she failed the Mcnaughton test. But it was very clear to everyone that she was severely mentally ill. There was medical records and everything that she was mentally ill. So some states have created this category called guilty but mentally ill. And the idea is that you can't meet the test for insanity, but you're mentally ill. But we're going to send you to a mental hospital for you to get treatment, because prison isn't really where you need to be. But since you're guilty, once you're done with your medical treatment, you may then go back to jail and spend the rest of your sentence in jail. Another concept we have is diminished capacity. This deals more with, do you have the intellectual ability to form mens rea? So if you suffer from some sort of intellectual disability, low-level IQs, things like that, then your brain cannot form the proper mens rea because it has diminished capacity. So that's another form of lack of capacity defense. It's not insanity, it's just you don't have the ability. Okay, and then another concept we have to talk about is what we call mental incompetence. In order to be charged in our system, you have to have the ability to understand that there's a trial going on, and you have to be able to contribute to your own defense. So this has nothing to do with at the time the crime was committed. This has to do with the time of the trial. Do you have the mental ability to understand there's a trial and help out in your trial? So sometimes you could be completely sane when you complete the crime, but by the time the trial comes around, your brain is not functioning properly. Then that means you are incompetent to stand trial. What's going to happen is they're going to send you to a mental hospital. They're going to try to help you. And then once they decide you are capable of understanding that there's a trial and being able to contribute to your own defense, then they will hold the trial. So it's just a postponement of the trial until they determine that you are now competent to stand trial. Okay, so that's it for insanity. So what I want you to do is use all of these tests and work on Chapter 6 assignment. So you'll read the scenario, and then you're going to tell me what each test is and tell me how it would apply to the scenario. Okay, so that will be your assignment for Chapter 6. So that's the first part of Chapter 6. There'll be one more video to watch. We'll talk about the other lack of capacity defenses, and then we'll finish up with all defenses in the next lecture. See you soon.